right, still morning. Yes, good morning, everyone. Here on our next case, which is Florida Health Sciences Center versus Jeffers.
It please the court, Diana Stein on behalf of the petitioner, Camden General Hospital, and I would like to reserve 5 minutes for knowledge. And we're here today asking the court to order the dismissal of counts 2 and 3 against the hospital, which allege negligent sterilization of instruments and negligent lumbar puncture for a complete, undisputed lack of corroboration by any qualified expert on those claims. Now, to be clear, this petition is about corroboration. It is not about notice. The hospital is required, entitled by statute to have a qualified witness sign their name to some.
Ms. Before we get all the way into the merits of the witness's qualifications, I want to talk to you a little bit about jurisdiction.
Yes, Your Honor.
I realize that we have precedent, Clear versus Lynch, that has been certified to be in conflict by the first DCA and Carmody. And having looked through Williams in our cases and Carmody, while puts you in a little bit of a quandary to give me a good straight answer to this question that I'm gonna like, but I'm questioning, given the timing with Carmody being certified, and I believe the court has accepted jurisdiction, how do we really have jurisdiction here? I know you're going to answer me with a little bit of Vandaria, the decision that Judge Lucas authored a few months ago, which is, in my mind, completely distinguishable because a verification is a procedural compliance issue. We're talking here about exactly the type of merits evaluation of the expert's qualification that Carmody disapproved, that Williams versus Oken seems to disapprove. And so I need for you to speak to jurisdiction a little bit before we go into the merits.
Certainly, Your Honor. And this was the situation in Rell versus McCullough. I mean, that decision was argued and came out after Williams versus Oken. The Supreme Court accepted jurisdiction of that. We went up to the Supreme Court.
But it's not clear on what basis they discharged, what basis it was invoked, or what basis, obviously what basis they discharged. So I took your point on that, but I went and looked at Rella to see if there was any sort of breadcrumb trail on what the conflict was.
Correct.
That they accepted, and I couldn't find it.
And I understood, but if you look to Williams versus Oken, I mean, that was one that went up on, that was after the first district reviewed it, and the Supreme Court came out, I think, quite strongly and said when an appellate court has to reweigh evidence, we're not taking jurisdiction. I would submit that had the court at all been offended by jurisdiction in Rell, it would have done something. But I'll go beyond that because we still have a trail of cases from this court with the first district certified conflict. Well, if the first district certified conflict, that means it agrees that this court's precedent means accepting jurisdiction.
And I understand, that's why I gave you the wind up on that. I understand that we have a prior panel decision that binds this court, but it's also in play given the certification and acceptance in Carmody. So that's why I want you to address it. I'm not sure how faithfully Williams has been adhered to in the decisions of this court.
I'd like to just speak briefly to the merits of Williams, and I understand the first district has disagreed with that. Williams predated the same specialty provision where the trial court would do more of an analysis and jury determination.
And I think somebody has addressed, in one of the cases, addresses exactly that point, that it doesn't, I think maybe it was Carmody, that said that doesn't really matter. And I'm not sure that's wrong. Williams says, I think in more broad terms, my read of it is that if you've got a procedural compliance issue that's certifiable, that will result in irreparable harm. If you have an issue of the appellate court needing to look at the merits of the expert's qualifications, that doesn't meet the criteria for certiorari jurisdiction in the irreparable harm. And again, I'm not quarreling with you over what our precedent currently says. It's just, it's a concern, and it's one that one way or another, you may have to deal with on the back end of this case, you know?
And I'll say this, I mean, we plaintiff moved twice for dismissal. We didn't have the opportunity, I mean, we did address it to some extent in the reply brief, but, you know, at best, this court, I think, is duty bound to accept its prior precedent if, you know, there's a conflict issue that can be dealt with down the road. But I want, if there was even a question of whether it could exercise its jurisdiction now, you know, I want an opportunity to address that perhaps more thoroughly. But I'll say now, I submit under REL, under prior precedent, this court, this 3-judge panel has to accept jurisdiction.
I mean,
if it finds there's.
we do have an avenue off of
Right.
having to accept that, but I'm
But
not.
I would, unless Your Honor has more questions, I mean, I do think the merits are significant. I think we could address them based on not an evidentiary analysis, but just on the papers, which again, I believe brings this under REL. And Your Honor, if we get back into jurisdiction, I'll certainly get back to
No,
it.
and I didn't mean to hijack you completely, but
Understood.
it sort of makes sense to get that cleared up out of
Understood.
it in the
We
first
stand by our
instance.
position right now. If this court finds a departure from the essential requirements of law, then its prior precedent means it has jurisdiction over these claims. As far as the departure from the essential requirements of law, and I do want to get to that because we have one expert below Dr. Oppenheimer, who by statute, by the plain language of 766.102 subsection 6, was qualified to even talk to any negligence by hospital staff. That Judge Barton heard this first. He made that determination. Plaintiff did not re-raise the other affidavits when they went before Judge Polo on the motion to dismiss the second amended complaint. So in other words, Judge Polo.
So that was law of the case. She couldn't touch it? Is that what you're saying?
If plaintiff says that she couldn't reconsider it, yet they didn't ask her to, and she didn't, well, it's like there's a case that we've cited in the briefs called Jeffrey A. Hunt from this case.
There's principles of comedy that need to be.
Yeah, and that's where Judge Silverman said, you know, they didn't re-raise this below, and if the trial court didn't consider it, we're not considering it on certiorari. So that was an abandoned argument. Judge Polo properly looked to Dr. Oppenheimer's affidavit only and looked to whether that qualified.
But Dr. Oppenheimer, which is the only Florida licensed physician, if I read his affidavit correctly, it was all about failure to diagnose and take next steps. It had nothing to do with what the medical staff, the medical support staff.
Yeah, that's correct. You're under.
And so what was Oppenheimer Oppenheimer as a neurosurgeon, we're left with Oppenheimer as a neurosurgeon, opining as to what an otolaryngologist and somebody else who's not a neurosurgeon, right?
Correct. That's absolutely correct.
And that's the guts of your merits argument, isn't it?
That's the merits argument, is that he doesn't even say the word sterilization, infection, or, you know, sterilization, lumbar puncture. I mean, infection, yes, she had access, but he just doesn't even talk to it. So it's void of any corroboration at all. The court's finding.
Well,
yes, Your Honor.
I mean, it kind of depends upon how, and this is one of these things that we're struggling with on the certiorability.
Certainty.
Yeah, we'll go certainty. On the certainty of these is that it depends how you draw the framework, right? I mean, he does talk about deviation from standard of care. He talks about abscess. And I'll be honest, it seems counterintuitive to me that someone who has these qualifications is just forbidden to speak or to even render an opinion that could imply or that one could infer said that there was something in the course of the surgery that wasn't done right. Especially when we're talking about the sanitation issue, which to me just it just strikes me as counterintuitive that a doctor that is otherwise qualified could not corroborate that surgical instruments need to be sanitary, and that wouldn't fall with just under the general rubric of, hey, this resulted in an infection, and this was a deviation of standard of care.
Judge Lucas, and that's exactly our point. We're not saying he's not, Dr. Oppenheimer is not qualified. Of course, he by law, if he did not say he was, that he knew the standard of care, but certainly by law he can. And our point is that he didn't. The plaintiffs had 90 days plus going into our pre-suit where their investigation was continuing because they were continuing to give the defendant affidavits. They had a lot of time to work this up and talk to their experts and say, we think we may have a claim about negligent instrumentation, sterilization. Can we support that? And this doctor, for whatever reason.
Well, for whatever reason, wasn't there some, I'll call it discovery dispute that kind of precipitated this in terms of when the notice was made, hey, we want these records, the hospital took the position, kind of a blanket, pretty broad, that no, we're not going to give them to you. Should we consider that in any way?
No.
For purposes of whether or not the hospital gets either sufficient notice or sufficient corroboration from a medical affidavit in conjunction with the statutory requirements.
Right, and I just want to clear the record on that the plaintiff took the position originally that they didn't get records upon request. The hospitals, that was a dispute, and that went before Judge Barton in an evidentiary proceeding, and it was shown that the hospital did immediately contact the plaintiffs, send records to the plaintiffs, sent a link of records to the plaintiffs. Plaintiffs, for whatever reason, didn't open the link expired, but it was found that the hospital cooperated with the pre-suit and didn't waive its right to discovery. The other thing that plaintiff said, I think there was a minor allegation that they asked during pre-suit within very broadly, I think names of, or very broadly about everything you have about sterilization of instruments, and there was an objection to that. When the plaintiffs filed their second amended complaint, they had no problem naming the scrub technicians. And what the defense counsel made clear below is that we're not asking for names. You could have just said, what happened, that a certain person was negligent, just corroborated, but that wasn't even done. And so I say that to show that this is any discovery issues are red herring, because that was determined in an evidentiary proceeding by Judge Barton, and it was determined that the hospital did not waive its right to corroboration.
Yeah, it's kind of a little bit strange to me that you're having an evidentiary hearing on what amounts to a pre-suit requirement that's not otherwise governed by the rules of discovery, right?
And well, I think that's the normal way of doing it, is that you have a trial judge decide whether the rights under the statute have been waived. And the trial judge, and he had all the correspondence before him and considered it. And, I think the record was pretty clear that.
These issues, to me, it just seems like that you need to have a good, before you have an evidentiary hearing, you need to have a good understanding of what the rules of the road are for the evidentiary hearing. And for discovery evidentiary hearings, we got pretty well established rules of the road. I'm not sure that we have quite as good an understanding of how these evidentiary hearings are supposed to be conducted, what they're supposed to go after, what's the level of objections that's even appropriate in these kinds of instances.
The parties went before Judge Barton on the letters, and there was no.
They showed the correspondence.
They showed the correspondence. No one contended that it was fraudulent or fake or not. I mean, that it was shown to the court, and there was no showing that the hospital made up records.
Your client would be in a better position if they had not raised the objection on the issue of the scrub technician. Would you agree with that?
I'm not sure I understand your question, Your Honor.
So it would just take the issue off the table entirely if they hadn't raised objections to the pre-suit stuff. Or are you saying that they didn't really object at the end of the day by virtue of Judge Barton's ruling, it just didn't amount to an objection?
We never objected to pre-suit other than the letters written informally. And that was to ask the plaintiffs for corroboration. Originally, the notice of intent just said, you, the hospital, are negligent, with no affidavits. And the hospital wrote back and said, we can't do this investigation without the affidavits. And that's that was the back and forth between the parties, and eventually we got the affidavits, they had the records, pre-suit went forward. The only objections, I mean, this isn't about a hospital objection, this is about a motion to dismiss. There was a motion to dismiss the original complaint, which the Judge Barton agreed with to some extent and had the plaintiff re-characterize the claim against Tampa General. And this is just about whether the 2 and 3, counts 2 and 3, the second amended complaint are corroborated. I mean, I think it's as simple as that, and for that we look to Dr. Oppenheimer's affidavit, which talks about, as Your Honor points out, it's just neurology. He had the opportunity to talk about sterilization, he could have. I think it speaks volumes.
So let me ask you a question about Oppenheimer's affidavit, and the allegation is they failed to properly evaluate, recognize, and diagnose, and failed to properly refer for a CT and for a neurological surgery consult. And they say that those breaches by Allen, Agassiz, and Tampa General led to this outcome, right?
Yes, Your Honor.
And part of what your opponent has argued is that TGH includes its providers. And if I'm understanding his argument correctly, providers include scrub techs. We have a statutory definition for healthcare providers. I don't remember this being exhaustively briefed, but what do you say to the notion that TGH broadly includes the scrub techs and that this could fall within the range of what Oppenheimer could corroborate?
So the answer to that is simple, and that is TGH is different than a neurologist, an otolaryngologist, a scrub technician, or any medical provider in the sense that it, as a hospital, can't practice medicine or commit malpractice. And the case law says as to a hospital, and this is, for instance, Goldman versus Halifax, and consistent with this court's decision in Mann, that if the hospital for pre-suit, you have to actually identify the active tortfeasor. So you can't just have a doctor say, I'm a neurologist and I believe the hospital was negligent, because that doesn't tell anyone anything if it's a hospital, because we don't know who the active tortfeasor is or what the negligence is. So, to say that just throwing in the name of the hospital when it's so clear from the corroboration that the expert hasn't corroborated what the statute says are support staff who are entitled to separate and their own corroboration, that is it's just not sufficient. I mean, there's nothing for the hospital to investigate. So
Just to let you know, you don't recall you asking for rebuttal time, but if you wanted 5 minutes, you're into it now.
I think these issues, I did ask for it.
You did?
I just think these
I'd like you to write
issues,
it down.
they're very important. I mean, I want to address all of the
Yeah.
court's questions, and so, I mean, I think that's a very easy and straightforward answer to that. There is not a case out there, even in the outlier cases from the 4th and 5th district, which I submit are now dated by changes to the statute, which now require more corroboration or same specialty. But even in those cases, the expert always, in the original corroboration, corroborated claims directly against the hospital. I mean, for instance, in the Davis case, there was originally corroboration about the problems in the first surgery with the CRNAs, with the doctors. So that was enough to bring the hospital in, and it was timely corroboration. In I think it was the Brown case, there was one where the emergency room physician and nurses were properly pre-suited, and they said, okay, that's enough corroboration to bring in other claims against the hospital. I say they're dated, and I think the Mann case shows it's dated because back then you can, it was not as, I'd say, restrictive on who's allowed to testify against each person. There is not a case in Florida that either side has found where you can just talk to the negligence of someone who doesn't even work for the hospital, who has nothing to do with the hospital staff, where the corroboration is not even determined to be, qualified as to the specific negligence, and it's not mentioned, and that says that's enough. I mean, this would be such an outlier case, and contrary to Rel, to Mann, to Bonatti, if this court were to hold that was sufficient. No court has ever held that an independent physician's negligence and then the words TGH or the hospital is enough. And I would point out the language in the Mann case because I think it's very significant. Mann's a short decision, but the court goes out of its way to say we find no corroboration against the nurses and supervisors. And I don't think the court said that for no reason. It could have just said no corroboration against the hospital. This goes away. It said the nurses and supervisors. So this court was carefully considering the fact that, you can corroborate some claims, but perhaps, not others, and those claims go out, the other claims stay in, and, that's what the statutes require. So, unless your honors have additional questions, I'd like to save the rest for rebuttal.
So ma'am, you have 3 minutes.
Thank you, your honors.
May it please the court, Martez Gordon from the Gordon firm, and here on behalf of the Jackmans. If I may, Your Honor.
Yes, sir.
Your Honor, the Tampa General Hospital is arguing that the trial court departed from the essential requirements of the law by failing to grant its motion to dismiss in regards to the scrub technicians and the anesthesiologists. In support thereof, Your Honor, they're citing 3 particular cases in which I would like to give this court, this panel, a brief snapshot of all of those cases very briefly and as to why those cases do not apply to our facts that are before us. They're citing the University of South Florida versus Mann, as articulated by opposing counsel here, stated that the court articulated in that particular case that there were no deficiencies that were directly associated with the supervisory nurses and the nurses. And because the affidavit did not corroborate any deficiencies as directly related to the nursing and the supervisor nurses, that the affidavit failed to corroborate claims against the nurses.
Well, how does the Oppenheimer affidavit corroborate claims against the Tampa General nursing staff for the instruments?
That's an excellent question, Your Honor, and I'm going to get to that point right now. Your Honor, the reason why our case is so distinguished from this particular case is that the difference is that its university recognizes that physicians, nursing, and nursing supervisors, that they're rendering the medical treatment or they're failing to render medical treatment will always be in the medical records of the person who's injured. You'll always find it. The difference in our case, Your Honor, is that there are no facts that you will ever find in the medical records from a scrub technician. The case law has already provided that the corroborative facts must be supported by the medical records. Dr. Oppenheimer could not do that because all of the medical records that was provided by TGH to us, that was provided to Dr. Oppenheimer, it will never mention anything about what the
Well, Dr. Shaya purports to corroborate this claim to some extent by having analyzed the cultures, which presumably were available to Dr. Oppenheimer as well.
Well, Your Honor, and that's a good point. But here's the thing, Your Honor. Their argument was that because Dr. Shield was a Virginia physician, that he had no authority to corroborate here. Your Honor,
Which is a different issue, but let's assume that we just need to look at what he did corroborate.
Yes, Your Honor, but we believe that the case law is clear in Florida that corroboration must be based on the facts that are outlined in the medical records.
Well, my question to you, though, we're kind of going around on this. Shaya, how you ever say his name, had access to records that gave him these cultures that let him opine to some extent about the use of non-sterile surgical instruments. Were those records not available to Oppenheimer?
No, Your Honor, those exact same records were provided to Dr. Oppenheimer, but the reason why Dr. Shea gave that opinion, if Dr. Shea's affidavit was before the court right now, it would be the same issue because in Dr. Shea's affidavit, he never directly named a scrub technician or neither did he name it by name or position. So even if that were presented before the court, we would have the same issue.
Well, let's go to the other thing with Shea's affidavit. He's a Virginia doctor, he's not a Florida doctor. And the statute says for opining against medical support staff like scrub techs. That in order to do that, a physician who's going to opine has to be licensed in Florida or under 458 or 459. Shia is not. What do you say to that?
Yes, Your Honor, and that's why I'm focusing more on Dr. Oppenheimer's affidavit. I believe that the Shia affidavit, the purpose of the Florida statute 766-203 section 2 is to ensure that the plaintiff has conducted an investigation to ascertain whether there's reasonable grounds to maintain medical malpractice. We believe that the affidavits, we provided them with 3 affidavits, Dr. Rubenstein, Dr. Shia's, and Dr. Oppenheimer's affidavits. We believe that those affidavits demonstrate that we met the purpose of the statute, which is to demonstrate that the claim is not frivolous, as articulated in mass amount of case law in the medical malpractice arena. So we do believe that in regards to the purpose of the statute, we believe that in conjunction that particular.
But wouldn't the point be that you need a licensed Florida healthcare provider to corroborate that, to bring a medical malpractice action in Florida? Isn't that really the requirement why they require a medical provider licensed in Florida?
Yes, Your Honor, and that's why I'm specifically attacking this particular argument from the lens of Dr. Oppenheimer.
Can we easily dispense with the anesthesiologist claims?
No, Your Honor.
Why not?
Because I believe that once I can establish to the court, or have an opportunity to establish to the court that the argument with the scrub technicians is valid, then that would give me the argument, the transition as to why the claims against
Your claim against the anesthesiologist is altogether different than the scrub tech claim. And the bottom line here is there is no anesthesiologist in this trio of experts.
Yes, Your Honor, and we believe that, but we believe that in the case law in the Columbia versus JFK Medical Center and in the Murillo case, we believe that the Murillo case outlined that there was a case in the Murillo case, Your Honor. Sorry, Your Honor, I apologize. But in the Murillo case, Your Honor, the court had dealt with that particular issue where there was a claim that was made. No, I'm sorry, that wasn't the Murillo case, Your Honor. That was the JFK case, I believe, the Columbia v. JFK case, where the court basically, there was a different claim that was brought in pre-suit that was actually that was brought in an actual complaint.
Well, we can cut to the chase on this because the statute that you're traveling under here requires a physician opining against another physician to specialize in the same specialty. And neurosurgery, these 3 experts, one's a neurosurgeon, one's a neurologist, and one is an otolaryngologist. None of those people are anesthesiologists. It's not even a pretext.
Well, we believe, Your Honor, as stated in the Judge Peterson's comment in regards to the Davis versus Orlando Regional, where it states that he starts by stating the purpose of the cooperative opinion. And then he states that it's impossible in a medical malpractice case to identify every instance of medical negligence. And so we believe that that case gives us the right to bring anesthesiologists in. But, Your Honor, if the court is not inclined to be convinced by that, Your Honor, I do think that certainly it's important to know the 2 particular roles of a scrub technician. Scrub technicians have 2 different duties. They have the duty to sterilize surgical instruments, and they have a duty to create a sterile environment during the actual surgical procedure, none of which will ever be found in the medical records, which is why Dr. Oppenheimer could not name it by name or position, which is why Dr. Oppenheimer could not associate any particular deviations or deficiencies as used in man to the particular scrub technicians, because there are no cooperative facts that can be brought. Had Dr. Oppenheimer corroborated anything against a scrub technician in the manner in which man proposes, or in the manner in which Benatti proposes, which adopted the Gregorian opinion, then they would have moved to have that opinion disqualified. Why? Because the case law states that every cooperation must be based on a factual basis supported by the medical records. My position is that if in my medical records, you will never find anything about what the scrub technicians did prior to cleaning the tools, and you'll never find any information about what they did in creating a sterile environment in the actual surgical procedure. And because they cannot
The
find
affidavit of Dr. Shea addresses that, right?
Yes.
So Dr. Shea saw it, so why could
Well-
not have Dr. Oppenheimer?
Well, Your Honor, Dr. Shedd, again, we've already discussed that Dr. Shedd is a Virginia physician, and if we were to say that his affidavit has no merit, and the only person whose merit would apply in this particular situation would be Dr. Oppenheimer, then it's important for the court to see that the only possible way that we could have cooperated and placed them on notice was by placing those facts in the notice of intent. Because the notice of intent, we believe that the notice of intent with the affidavit together placed them on notice. We could not do it through the affidavit for the reasons that I just articulated, because there are no facts in the medical records, there are no names of the scrub technicians. So in order for Tampa General to take the position that we should have named it either by name or position, stated the standard of care and how it was breached, that must be done as articulated in the medical records, but that information is not there. That's why the Mann case doesn't apply. That's why the Benatti case doesn't apply. That's why the logic that was employed by the Gregoria case doesn't apply, because the courts in that argument, they reasoned and they articulated properly that if an investigation had to take place, then you should have been able to name that particular physician or those nursing
Let me
persons.
see if I can distill what you're saying down to something pretty simple. You're not really relying on Shea's affidavit because he's Virginia licensed. Am I correct for the scrub text?
Yes.
You're conceding that point.
Yes,
Okay. So from there, we go to Oppenheimer, who is Florida licensed and can opine against the scrub text. And as I understand your argument, it is that Oppenheimer couldn't specifically opine on the duty or the standard of care or how it was breached, because there was nothing in the medical records that reflecting what the scrub text did or didn't do.
no, Your Honor, that's not my.
Okay,
my
but
position.
what are you saying? Because the bottom line is the same medical record that Shia used to identify these cultures and opine that that was the product of bad sterilization was available to Oppenheimer, and Oppenheimer didn't deal with that.
Well, Your Honor, if you were to analyze Dr. Shear's affidavit, well, Your Honor, in regards to that previous concession, no, Your Honor, I don't concede that. If you look at Dr. Shia's affidavit, he makes a sweeping statement where he states that because of the sterile instrumentation, it has to be a lack of sterilization in order for these particular cultures to be found within her brain. He didn't list that this was a scrub technician. This was as a result of, he didn't name a person by name or party, and he didn't attack any deficiencies. But Dr. Oppenheimer, because providers have been defined by Florida statute, there is a definition for providers. Your Honor.
And is it
Dr.
your
Oppenheimer-
position that scrub techs fall within the definition of healthcare provider in 766-2024?
No, it's my position, Your Honor, that the only way that we could have placed Tampa General Hospital on notice, it is our position that man does not help us, because man stands for the position that you have to attach the deficiencies that's supported by the medical records to the nursing supervisors or the supervisory nurses. Because there are no medical records that will opine on anything that the scrub technician has done. You won't see anything in the medical records. It's not something that's there. As far as a physician or nurses, it's universally recognized that their rendering or failure to render medical treatment will always be in the medical records. In this particular instance, Your Honor, it's not there. So in order, if you were to balance a citizen's access to court, and you say, well, Dr. Oppenheimer's affidavit failed to name scrub tech or failed to attach deficiencies to a scrub technician, therefore it doesn't pass muster, then you
Well, it
essentially-
doesn't. What he's
Yeah, go ahead.
required to do is opine to the standard of care for the scrub techs, whoever against whom the claim is asserted. And Oppenheimer's affidavit not only doesn't say anything about any medical support staff, it doesn't say anything about instruments or infections or bacteria or anything. And so
Well, Your Honor, the case law doesn't just mention standard of care. If you go through those case laws meticulously, Your Honor, the Allen versus Donati case essentially adopted the opinion of the third DCA.
Well, the statute is what specifies the requirements for the corroboration. So that's what I'm focused on.
Yes, and so because the statute, but remember the statute, even though the statute does specify the corroboration, what we're saying that this is one of those cases where the facts places us in a gray area, because there is no way that had Dr. Oppenheimer stated that the scrub technicians deviated from the standard of care, and here's their deviations, Tampa General Hospital would have moved to have that opinion disqualified. Why? Because the case law has universally and unanimously interpreted that those deficiencies
Couldn't
must
he
be
have
supported by
opined-
case law.
Couldn't he have opined, like Shia apparently did, that based on on the findings that Shia cited, that there was a standard of care issue associated with the sterilization of the instruments? Couldn't he, I mean, I think all we're talking about is the standard of care
Your Honor,
and what the medical records show in connection to it.
I'm not sure, because the case law, Your Honor, when we talk about the standard of care, I believe that in the affidavit that was cited by Dr. Oppenheimer, I believe that he provided enough information in order to infer that the standard of care was breached. Because as we articulated in our response motion, Your Honor, that those bacteria and those abscesses, Your Honor, those are as a result of an infection. Abscess are a result of infection. So we believe that he touched it, and he touched on it enough in order for him to utilize his professional and his medical prowess in order to give enough information on it, but not to exceed the bounds where he would be disqualified. And that disqualification would result in the deficiencies must be supported by the medical records. But again, Your Honor, if there's nothing in the medical records that talk about what was done during the
So
sterilization
who's your
process,
best expert for count 3, the claim against the anesthesiologist and the PA?
against the anesthesiologist?
Your count 3 is the lumbar puncture. The 2 providers that you've targeted for that are an unnamed anesthesiologist and an unnamed PA. Who is corroborating those claims?
Your Honor, we're at the position, we're taking a position that we did not have to corroborate that claim, because we don't have to corroborate every single act or delineate every single act of medical malpractice. Your Honor, we brought so many, we've alleged that it was apparent through a parent agency that Dr. Severo Agazi, that Tampa General Hospital was liable for the medical negligence of Dr. Agazi through a parent agency. So we believe we effectively corroborated that. We also corroborated our theory against Dr. Kyle Allen. So if we were to have to go down through every single piece of medical records and meticulously find everything that they've done wrong and get an expert for every single one.
So it's your position that even though you bring a specific count directed to the anesthesiologist and PA based on the specific issue surrounding the lumbar puncture, and you've got at least one expert opining that specifically concerning the puncture, you don't need to corroborate that claim?
Yes, Your Honor, we believe that under the rationale that was employed by the Columbia JFK case, we believe that you don't have to find every single act of medical negligence. Because if that was the case, Your Honor, we would go down a fishing expedition. We believe that the purpose of the statute is to maintain the fact that that the claim is not being frivolous, not to delineate every single act of medical negligence. If that were the case, Your Honor, we would have so many experts. When you go through the voluminous amounts of medical records, we would have to get an expert for every single person that has done anything wrong. And we don't believe that that was the intent or the purpose behind the statute. And if that was the intent, then I believe that you have to balance that with a Florida citizen's right to access to court. And that's why I believe that the only way we could have placed Tampa General Hospital on notice is by placing the deficiency with the surgical instruments in the notice of intent. If we placed it in the affidavit, we would run afoul to the case law that says it has to be supported by medical records. So now my expert is in a position where if he places that in his medical records, he can look at having a disqualification, in which we know, Your Honor, that once an opinion is disqualified, you have to disclose that to every court after you you've provided them your opinion. So now my expert is in a position to say, well, listen, if I say this and I have nothing in the medical records, because there is no medical records that will ever discuss this. So in Bonatti versus Allen, Bonatti's name wasn't named. Why? If an investigation was taking place and Bonatti was in those medical records, it's inexcusable not to name him. In the Wayne case,
Well, there's a big difference between, in putting aside the question of whether you have to have individuals specifically named, there's a big difference between saying and corroborating a claim against the medical staff based on sterilized or unsterilized instruments versus dragnetting the whole case into an affidavit that one specialist has given that speaks to specific procedures and not much else.
Well, Your Honor, in the main case, as articulated by opposing counsel, she even stated before the court that there was a reason why the court stated that the nurses and the supervisory nurses, that the affidavit contained no deficiencies that were directly associated with the nurses and the nurses and supervisors. The courts have already stated in the Maddox case, Your Honor, that those deficiencies have to be supported by the medical records. So if you're saying that that's the standard, then the question becomes, if we stated that the standard of care was that the surgical technicians reached the standard of care by not sterilizing the tools. And then the case law says, well, where's the case law is universally addressed that these deficiencies must be supported by the medical records. When Tampa qualified, can you show us where in the medical records give you these deficiencies? We have nothing to point to because it's not there. And that's the difference between the Bonatti case, who's a physician. That's the difference between the Mann case with supervisors and nursery supervisors. Their rendering or failure to render medical treatment will always be in the medical records. With scrub technicians, they sterilize instruments before a surgery ever takes place. That's what ordinary negligence comes through. At the actual surgery, they create a sterile environment. And if an infection took place during the actual sterilization in a sterile environment, then it falls under medical malpractice. So it's two.
So let's talk about your ordinary negligence argument for a minute. Is it your position that obviously count 3 can't be ordinary negligence, but is it your position that count 2 is ordinary negligence?
It's my position that it can fall under both because there's 2 duties of a scrub technician. One of the duties of
Is the medical, let's take it one step at a time. Did you preserve the ordinary negligence argument in the trial court?
Your Honor, I believe that one second, Your Honor.
You argued in your brief that it's preserved, but I didn't see it mentioned in the transcript of the hearing before Judge Polo or in your opposing memo. I can always be educated.
Mr. Warren, just to let you answer, please answer Judge Britt's question, but we're over your time now.
Okay,
So
I'll
we need to wrap it up.
Then I apologize. I'm just trying to find it in my. Yeah, I apologize, Your Honor. I didn't expect that question, Your Honor, so maybe I should have anticipated it.
We'll need to maybe just take a look through the record and make sure that issue's preserved, which is something we can certainly take a look at. All right, thank you, sir. Go ahead, Stan.
Thank you, and thank you, support. This is really what the legislature was trying to prevent, is that, claims going forward, when plaintiffs have now spoken to, 3 experts, 2 unqualified. Now, one of them is willing to go out on a limb on the third count 3 of negligent lumbar puncture, in fact, says didn't cause any injury to the plaintiff. Now, one of them is willing to go as far as saying that the sterilization of instruments was negligent or a deviation from the standard of care, and the only Florida physician qualified to make this decision, which again, you have to assume that plaintiff spoke to that physician in pre-suit, worked with them, tried to come up with claims, and he just was not willing to even speak to the very issue of sterilization, which is, now the whole point of count 2. So this is what the legislature is trying to prevent since the Brown, and as I've said, the Davis cases came out. These are older cases. Subsection 6 didn't exist then, requiring specific qualifications against support staff. The same specialty provision didn't exist then, so presumably the same expert could have dragnet all of the claims into the case, like that term, because that's exactly what happened here, is that plaintiff's physician is going to take a non-employee of the hospital, a surgeon, and just use a claim against them and then just say a parent agency, and now everything against the hospital comes in. That is not the law, that is not permitted. It is against the Mann decision, Rel, Bonatti, and it is clearly not supported by any case law in any court. So we would submit, first of all, that at this time, the court has jurisdiction, just based on the clear precedent of this court, if it finds, and it should find, that allowing these claims to go forward is a departure from the essential requirements of law. They should be, the order denying the dismissal should be quashed. Plaintiffs should not be permitted to go forward on those claims.